It might seem strange and even wrong to date the origins of civil rights and civil liberties to the year 1937. It seems wrong because most of us believe that our rights have an older pedigree than just 76 years. Some believe that our rights have their origins in nature or nature's God, thus defying its synthetic man-made origin. From this perspective, the Constitution merely marks in writing a set of rights that are at least older than 1937. But in this segment, I want to suggest to you that our recognition and application of most of the rights we deem fundamental, most of the rights in the Bill of Rights, are rooted in the year 1937. What was so seminal about 1937? Well, most importantly, the country had been in the thralls of the Great Depression for almost 8 years. By 1937, Democratic President Franklin Roosevelt, along with a majority in Congress, had been trying to fix the dire economic crisis and prevent another one by passing legislation that sought to rein in, correct, and prevent another economic catastrophe. FDR's programs, though, were often met with criticism, especially from the Supreme Court. Criticisms that sometimes led the court to deem some parts of the New Deal unconstitutional. Even though FDR and the Democrats had the White House and large majorities in the House of Representatives and the Senate, the majority of the Supreme Court was made up of justices appointed for life, as all justices are, by previous Republican administrations. These justices, known as the Four Horsemen, plus another one, Justice Owen Roberts, had a fundamentally different vision of the power of the national government in the regulation of the economy than did FDR. This vision imagined a much smaller and limited role for the national government to play, and they often enforced this vision through a limited reading of Congress's power to regulate interstate as opposed to intrastate commerce. The majority of the Supreme Court largely held to the idea that the Congress was limited to this less charitable reading of the Interstate Commerce Clause, and more importantly, that the Constitution protected a laissez-faire notion of liberty of contract that was, by the 1930s, the particular province of the court to protect against national overreaching. As a result, the court struck down some key provisions of the New Deal by the mid-1930s, including the National Labor Relations Act and the Agricultural Adjustment Act, as well as some other signature measures, including in some situations minimum wage, maximum hours, and child labor legislation. FDR was frustrated with the court. It seemed to be standing in the way of his and Congress's ability to rein in the negative effects of the Great Depression. Moreover, the criticisms levied by FDR charged the court with a cardinal sin, reading into the Constitution, particularly the 14th Amendment's Due Process Clause, something that wasn't there, a particularly conservative view of liberty of contract. In this view, the court was, in the words of Oliver Wendell Holmes, adopting an economic theory that was contrary to what the people wanted. Holmes wrote those words in a case called Lochner versus New York in 1905. This case came to represent the court's conservative posture up until 1937. In fact, we still refer to this period of American constitutional development as the Lochner era. In Lochner, the court considered a challenge to a New York law that regulated the amount of hours that bakers could work in a week. In the era of vast industrial development and change in the United States during the turn of the 20th century, many state legislatures passed laws like those in New York that were designed to protect the health, welfare, and safety of workers. The court, though, ruled that the legislature had violated the Due Process Clause of the 14th Amendment by regulating the contract rights of workers, the bakers, and their employees, the bakery owners. From the court's perspective, the state of New York exceeded their powers by getting in the way of naturally occurring contracts that workers and employees would make with each other. In other words, this type of legislation prevented employers and workers from negotiating a wage and the terms of a contract. The court was thus giving heightened protection to a certain conception of economic rights that was not specifically enumerated in the Constitution. Increasingly in the first third of the 20th century, but especially during the 1930s, the court's interpretation of the Constitution thus differed dramatically from the interpretation of the Constitution by FDR's New Deal coalition. But in 1937, the court backed down from this heightened protection for property and contract rights, ending the Lochner era and ushering in a new conception for the court's role. The court in 1937 gave up its previous role as a strict supervisor of economic rights. But now, what was the court to do? Interestingly enough, while the court gives up its strict supervision of economic legislation on the state and national level, After 1937, it increasingly replaced concerns with economic matters with issues of civil rights and civil liberties. But as they did this, the concern with the court recognizing and then strictly enforcing unenumerated rights remained. As we begin our study of civil rights and civil liberties, you should keep in mind the relatively recent origins of civil rights and civil liberties. Just as important, remember that the court's protective stance in favor of recognizing and protecting civil rights and civil liberties has unique origins in the recent past. Also keep in mind that some of the rights and liberties that the court will announce exist and then will protect are not written down in the text of the Constitution, the right of privacy, for example. And while of course some of the rights are written down, like the Fourth Amendment, the court will nevertheless read and interpret those provisions in a particular way that you might disagree with. So we have a tough but fascinating journey ahead. Not only will we be faced with deciding which rights are important enough to announce and enforce, but like the court, we also have to find supportable ways to enforce and interpret those rights.